For our final set of flash talks are Asaf Lubin and Justin Hemmings. So Asaf is a former intelligence analyst with the IDF. He's at the Berkman Klein Center for Internet and Society at Harvard University and is a lecturer at Yale. And he is going to be speaking on cyber insurance. Justin Hemmings is research faculty member at Georgia Institute of Technology and project attorney at Alston Bird, and he will be speaking on the definition of possession, custody, and control as defined in the Cloud Act. And remember, these are 5-minute speeches, elevator pitches. Asaf, you first.
Thank you very much to Third Way and for the Journal for National Security Law and Policy. My paper titled Cyber Insurers and Cyber Constables, Strange Bedfellows argues for the need to develop a stronger partnership between commercial cyber insurers and law enforcement in the criminal and civil enforcement of cyber norms. Cyber insurance, for those who don't know, is a risk management technique by which privacy and network vulnerability risks are transferred to an insurance company in return to a fee, the insurance premium. The global cyber insurance market now is worth $4 billion worldwide, and according to some researchers, it is likely to grow to more than $20 billion by 2025. A common conception in the economic literature is that private insurers can outperform the regulatory functions of government, courts, and law enforcement. By tailoring the price of the insurance product to the specific security posture of their insured, commercial insurers are able to financially incentivize policyholders to implement best practices and mitigate risks. In so doing, insurers become standard setters and enforcer of a now outsourced regulatory environment around safety. In my paper, I argue that adopting this paradigmatic, free market-driven view of insurance as regulation in the cyber domain is dangerous. The unique challenge of enhancing national cyber security demands a true public-private partnership. Insurers simply lack sufficient security data and cyber expertise to unilaterally take on the monumental challenge of managing the vulnerabilities of our interconnected lives. These private insurers also lack broader societal perspectives and public policy reasoning that only government and law enforcement can introduce. I thus propose in my paper various regulatory interventions necessary to address the negative externalities of the cyber insurance market. This includes, among other things, cooperation around cyber risk actuarial modeling and the development of aggregated claims data depositories, as well as collaborations around the promotion of best practices for forensic investigation and cyber attribution in claims investigations. Within the limits of this presentation, however, I will only focus on one example, one we discussed a lot today, which is ransomware insurance. Because hackers cleverly seek extortion payment at a price much lower than the cost of full recovery, and in fact are even willing to negotiate that price with their victims, many choose to pay the extortion. In pain, however, society suffers as we invite the extortionist to repeat the crime on other victims, with the extortion payment providing the necessary resources to sustain and expand their criminal operations. This is where cyber insurers might play a role in preventing this moral hazard by denying coverage for such extortions. In reality, however, far from denying coverage, insurers seem happy to chip in. Insurers are willing to cover these extortion payments and on many occasions even advocate for their payment precisely because U.S. public policy on ransomware remains ambiguous. When the Los Angeles Community College District was hit with a service-crippling ransomware attack in 2017, the Los Angeles County's Sheriff Department refused to discuss with the chancellor of the struggling college district whether the ransom should or should not be paid. A spokesperson for the Sheriff's Department simply stated squeamishly, "We would never recommend what to do in these sensitive situations." On the federal level, we see the same type of finicky behavior. In a December 2018 Interagency Guide to Chief Information Security Officers, or CISOs, the U.S. government merely encouraged ransomware victims to contact the FBI or the U.S. Secret Service and discouraged paying the ransom. Nonetheless, it left this serious decision in the hands of the CISO, who was called to evaluate all options to protect the shareholders, employees, and customers. Note that the CISO is not called to evaluate broader societal norms that in any event the CISO is unsuited to properly measure. Equally troubling, today most cyber insurance policies exclude language that would require the insurer to notify local law enforcement, let alone comply with their demands, prior to any indemnification of extortion payments. As a result, as we have heard, many ransomware crimes go unreported. Insurers claims that if they introduce such notification requirements, no one will purchase their policies, as policyholders would fear the repercussions of such disclosure or cooperation. But this race to the bottom is nothing short of absurd. How is law enforcement expected to carry out its duties and eradicate this ransomware epidemic if it is not being informed of the hacks in the first place? A state-level regulatory intervention is thus necessary to mandate such notification and collaboration across the insurance industry. Looking beyond notification, and unlike Assistant Director D'Ambrosio's position, I believe regulators and enforcement agencies should develop guidelines for deciding on a case-by-case basis when to allow or deny ransom payments and indemnifications. Such guidelines could be a first step towards a broader national enforcement program, which has become necessary given the scope and volume of ransomware attacks in recent years. For example, we might allow indemnification in the case of a substantial risk to life and property, and deny it if the cost to the insured from dealing with the ransomware through data recovery processes would be significantly lower. Whatever policy we adopt, federal and state regulators and law enforcement must realize that substituting their cyber decision-making with that of a private insurer and their policyholder is an abrogation of a core responsibility at a time where their steady hand on the wheel is most needed. Quite simply, if we are ever to close the cyber enforcement gap, we must acknowledge the role that insurance plays in cybercrime prevention puzzle and adopt policies that better orient the insurers to support public policy goals. Thank you very much.
Thanks, everyone, for sticking around through the end, and thanks, of course, to our hosts. It's been a really fascinating day, and it's been a pleasure to be here on behalf of my co-authors, Peter Swire and Srinidhi Srinivasan. Our paper is on defining the scope of possession, custody, or control in the Cloud Act, and is part of an ongoing research project we started back in 2015, the Georgia Tech Research Project on cross-border requests for data. We also do a lot of work in this space and on mutual legal assistance regimes in general as part of the Cross-Border Data Forum, which you can find by Googling, and we've written on e-evidence, the Budapest Protocol, issues of data localization, and other things in this space. As we heard over lunch, the Cloud Act in particular introduced this new alternative to mutual legal assistance treaties and this idea of qualifying foreign governments, but also very importantly, did not extend any new authorities for the request or production of data. What that second piece also speaks to is, in addition to this new framework, the Cloud Act in part was passed and amended to moot the Microsoft Ireland case that was before the Supreme Court, where this long-standing doctrine, the Bank of Nova Scotia doctrine, was sort of under review, and a few of the judges in earlier decisions had said, while we can rule on this, we really do think Congress should step in and solve the issue, which ended up happening by inserting this phrase that now law enforcement has clearly the ability to require the production of evidence within an entity's possession, custody, or control, regardless of where the information is stored. So in Microsoft's case, it doesn't matter that it's on a server in Ireland, you have control over the data, you have to respond to legal process. The trick, of course, is that this phrase, possession, custody, control, is nowhere defined in the Cloud Act, nor is it defined anywhere else in US law. So for law enforcement in particular, what this means is you have this strange, even though it's an extended doctrine, you can have an issue where individuals might either under request, so refuse, not ask for as much data as they're capable of getting because they don't want to overstep the bounds, or you might get over requests, over-interpreting what this phrase can mean, and subsequently having issues with your investigation on that end. So what we did look at was, it turns out the same phrase exists in a similar context in the Federal Rules of Criminal and Civil Procedure, where it says that these are the rules by which you can determine when evidence has to be turned over in the course of discovery. By looking through that, we developed a new visualization tool for how courts have examined, particularly determining control. Possession and custody seem to be a bit more perfunctory, but control is a bit sticky. And it turns out from our research that the courts tend to look at essentially two axes of data, whether or not there's evidence of a legal control, so like legal ownership of data, or day-to-day control. As a matter in the normal course of business, are you handling the data, processing it, using it regularly? And whether there's enough of either one or both of these axes, courts have generally been able to find control, and therefore you have to turn over the data. So one thing that came out of this was we raised 4 areas where we thought it was important to dig in a little deeper. The first is this question of how does corporate formalities, corporate structure impact this analysis? So if you're a subsidiary and the data is actually held by a parent, how does that come into play? The second is that in relation to the rules in that context, there's this difference when you're requesting data from a party to the suit versus non-party to the suit, because there's different incentives at play inherently for a party to not turn over evidence, so the threshold gets lowered. How does that port to the Cloud Act context? third issue we looked at was if or when to pierce the corporate veil, attribute control up the chain, and why that's different than the corporate finance context when you're talking about piercing the veil in a different sense. And then fourth, we looked at this issue that got raised from some of our colleagues in the EU who heard the word control and thought, aha, GDPR, that means you're a data controller. And no, it very much does not mean that. And so we looked through that as well. And then finally, we looked at other standards similar to the possession, custody, and control that exist in different areas of international law. And we really focused in on Belgium and recently the Yahoo and Skype cases where the Belgian Court of Cassation held that these companies had to turn over data that wasn't stored in Belgium because they were under Belgian jurisdiction, and therefore, of course, you have to give us what we're asking for. So as a result of all this, we came to three broader conclusions. The first is that no matter what, when courts have to determine possession, custody, and control, it's going to be a very fact-specific, totality of the circumstances type of analysis. They're going to look at a lot of issues, one of which will be corporate formalities, but never will that be determinative. The second is that we think they're going to be more likely to attribute control when you're looking at the target of an investigation for similar policy reasons as to why they do that with parties to the case, non-parties to the case, and also because piercing the veil for evidentiary production reasons doesn't have the same negative policy implications you get in corporate finance. And then finally, no control does not mean you are a data controller, which has two things. First, just because you have control under the Cloud Act doesn't mean you have to act as a data controller for purpose of the GDPR. And second, just because you are defined as a data processor by contract for purpose of the GDPR does not mean you do not have control over the data for the Cloud Act context and can't be required to turn it over. So thank you very much, and I hope you all enjoy your drinks.
Well, what a great day. Closing us out to give us remarks is Ari Schwartz, who is the Managing Director of Cybersecurity Services at Venable. And when we started this cyber initiative, Ari was one of the people we went to first and gave us just tremendous advice. So I just, from Third Way's perspective, tremendous thanks to Ari for all his help and his advice. Ari was former Special Assistant to the President and Senior Director for Cybersecurity on the U.S. National Security Council during the Obama administration. He's on our advisory board. He's at Venable that is sponsoring this wonderful reception that we are about to partake in. So please welcome Ari Schwartz.
Thank you, Jim. It's a pleasure to be here. When I was talking to Third Way about speaking, they said, well, could you do like a 20-minute closing? And I was like, sure, I could do less than that. So now I have 5 minutes. But I was totally inspired by those 7 flash talks. And so I will say, if you missed one of them, you should read the paper. It's going to take you longer than 5 minutes, though, so you sort of missed out here. But I'm not going to bother to try and summarize those because they were pretty intense as they were. But I will try and summarize the rest of the 7 hours that you spent here today, or that you, if you missed any of it. So first, let's say Congress is listening. That's one of the things we heard early on here on these issues, and they're trying to get more tech savvy. A lot of work being done on that front and trying to take on cybercrime through what they're learning with more technical people on staff and listening to the tech folks. Second, law enforcement is facing more and more cybersecurity challenges at all levels and needs more resources to do it. Third, and this is kind of the constant theme in cybersecurity going on for 20 plus years, information sharing, both from industry to government and government to industry, continues to be a challenge, but efforts to standardize government requests are beginning to move forward as a positive sign. We rely very heavily on the fact that criminals make mistakes, and that allows for attribution or for being able to challenge ransomware, and something that I can say from the work that we do at Venable, calling up the FBI and Secret Service and getting help from them, and before you go and try and pay a ransom is a good idea. These days, they've gotten their act together and gotten it down. International cooperation is improving, but more work is needed. The Budapest Convention discussion at the Council of Europe will be critical to watch going forward. With that, I want to thank the Third Way for putting this great event on. Please join me. Thanks to NYU for hosting. And so then what's next? So one thing we heard from everybody was that industry, government, academia, NGOs need to work together to solve the problems. How do we do it? Well, I'm going to go to what Mr. Tanzawa said at the end of or at the beginning of his talk, where he said that the size of your network really matters, and that networking is key. He was talking about it in the law enforcement context, but I want to talk about it in the networking cocktail hour context, right? We can all help to build our networks by staying together here and enjoying the drinks and food that we have here. So I'm going to close with that. Thank you very much.